एवरीवन, वेलकम बैक टू माय चैनल। अगर चैनल पे नए हो तो चैनल को सब्सक्राइब करें, वीडियो को लाइक करें ताकि आने वाली वीडियो की नोटिफिकेशन आपको मिलती रहे। एंड द मोस्ट इम्पॉर्टेंट थिंग, वीडियो के लास्ट में जो वर्ड्स हमने डाले हैं उनको एक बार ज़रूर देखें, उनको एक बार ज़रूर रीड करें, उनकी स्पेलिंग्स पे और उनके टाइपिंग मेथड पे ज़रूर ध्यान दें, जो कि आपके लिए लीगल्स मैटर में बहुत ही ज़्यादा इंपॉर्टेंट रोल प्ले करेगा। तो चलिए वीडियो को स्टार्ट करते हैं। Yes, be ready. 5 seconds. Start. The petitioners have preferred this writ petition under Article 226 of the Constitution of India, claiming the following reliefs: that by an appropriate writ, order or direction, the respondents may kindly be directed to pay wages to the humble petitioners at par with the regular employed senior treatment supervisor and TB health visitors along with dearness allowances. Stanza. Any other reliefs to which the petitioners are entitled may be granted in his favor. The writ petition may be allowed with costs. Learned counsel for the petitioners prayed that their representations may be considered by the respondents in light of the judgment passed by the Honorable Apex Court in the matter of State of Punjab and others versus Jagjit Singh and others, reported in 2017 1 Supreme Court cases 148. The relevant portion of the judgment reads as under para, having traversed the legal parameters with reference to the application of the principle of equal pay for equal work in relation to temporary employees (daily-wage employees, ad hoc appointees, employees appointed on casual basis, contractual employees and the like). The sole factor that requires our determination is whether the concerned employees before this court were rendering similar duties and responsibilities as were being discharged by regular employees, holding the same corresponding post. This exercise would require the application of the parameters of the principle of equal pay for equal work, page 101, summarized by us in paragraph 42 above. However, insofar as the instant aspect of the matter is concerned, it is not difficult for us to record the factual position. We say so because it was fairly acknowledged by the learned counsel representing the State of Punjab that all the temporary employees in the present bunch of appeals were appointed against posts which were also available in the regular cadre establishment. It was also accepted that during the course of their employment, the concerned temporary employees were being randomly deputed to discharge duties and responsibilities which at some point in time were assigned to regular employees. Likewise, regular employees holding substantive posts were also posted to discharge the same work which was assigned to temporary employees from time to time. There is therefore no room for any doubt that the duties and responsibilities discharged by the temporary employees in the present set of appeals were the same as were being discharged by regular employees. It is not the case of the appellants that the respondent-employees did not possess the qualifications prescribed for appointment on regular basis. Furthermore, it is not the case of the state that any of the temporary employees would not be entitled to pay parity on any of the principles summarized by us in paragraph 42 here in above stop. There can be no doubt that the principle of equal pay for equal work would be applicable to all the concerned temporary employees so as to vest in them the right to claim wages at par with the minimum of the pay-scale of regularly engaged government employees holding the same post stop. In view of the position expressed by us in the foregoing paragraph, we have no hesitation in holding that all the concerned temporary employees in the present bunch of cases would be entitled to draw wages at the minimum of the pay scale bracket start at the lowest grade in the regular pay scale bracket clause extended to regular employees holding the same post stop. Consequently, the present writ petition is disposed of with direction to the respondents to consider the representations of the petitioners in terms of aforesaid law as extracted here in above stop. The needful be done within a period of 60 days from today. Para. All interlocutory applications stand disposed of accordingly. Para. Abandonment. Above mentioned absolute discharge, ab initio, abscond, abuttals, accumulation, acquit, act of bankruptcy, actus reus, ad idem, adjourned, sine die, admonition, adoptive child, ad valorem, affray, aggravated, assault, aiding and abetting, align. Stop stanza.